welcome to Crime and Court. My name is Heather, and this, as you can see from the thumbnail, is episode 52 of the Canton Cover-Up Commonwealth versus Karen Reed. And we are going to be talking about a verdict. Was there a verdict reached? And if there was it judge's error or more misconduct as to why we didn't hear about it? But before I get into this, so actually, hold up, let me back up a little bit. So I was actually going to plan, I had another episode planned. I'm going to talk in the next episode, so keep an eye out for this one. So episode 53, we're going to be talking about what happens once there is a hung jury. I'm going to be reading through like a scholarly paper that some uh, lawyers and researchers had put together regarding what happens when there's a hung jury and why that affects an individual when a verdict isn't reached, and how, what does that do to the individual? Why do we keep going back, and doesn't it prove, if there is a hung jury, that the prosecution didn't meet their burden? So we're going to kind of talk about those points. So kind of make sure you're subscribed for that upcoming episode. And in this episode, today we're going to be reading through. So the defense came out today with a motion to dismiss based on some issues going on within the jury of the Karen Reed trial. So, and we also have some affidavits from both David Yannetti and attorney Alan Jackson. We're going to read through both their affidavits and their motion to dismiss charges on for Karen Reed. But first, I wanted to read you really quickly, give you an update about Michael Proctor. He's obviously, the lead investigator of the Karen Reed case. He said some horrid, awful, disgusting things about Karen to his buddies, his sister, his, wife, whoever he was talking to. He would just, tell them all about Karen Reed, her medical issues, call her horrible names, all sorts of things like that. Wish that she was no longer on this planet alive. Um, so yeah. So there's that. So you know what he said. So he had an evidentiary or a judicial hearing. What is it? What do they call it? Sorry, the words are escaping me right now. So he had a hearing today, and this is just talking about his hearing. So duty status hearing. It's right in there in the title. So it's scheduled for today. There's no cameras, it's not open court, so we're just going to have to wait until somebody reports on what happens here. And at this point in time, as I am recording this early afternoon of July 8th, I don't have anything more to say. This is the most up-to-date information. So this is from the Boston Globe, written by John Elements from the Globe staff. So embattled state police trooper Michael Proctor is scheduled to face his superiors Monday in a closed-door hearing that will determine his immediate future with the agency. The primary investigator in the Karen Reed case, Proctor, was relieved of his duties as as a detective in Norfolk District Attorney Michael Morrissey's office after his crude and demeaning text messages about Reed came to light at her trial. So he was relieved of his detective role. He was not fired as of yet. He still has to go through the whole process, and we'll see if he gets fired. So Proctor's removal from his role as a detective. It's very deceiving how the media likes to portray these things, because calling it a removal doesn't make it so. He's still he's still an officer of the state Massachusetts State Police at this point. So Proctor's removal was announced hours after a judge declared a mistrial in the high-profile case Reed 44 of Mansfield is accused of striking her boyfriend, Boston police officer John O'Keefe. Okay, we know that. So Proctor was transferred to a desk job at Troop H in South Boston. So that's where he's spending his days now after he was transferred from his role as a detective, not fired. Monday's duty status hearing will be held virtually and is not open to the public, a standard department practice. Proctor is expected to attend remotely, a state police spokesman said. Proctor's superiors have four options: restore Proctor to full duty, which I seriously hope that they do not do, and they could place him on a limited duty, like remove his badge, his gun, and take away his car, like they've done so far, and keep him working at Troop H on desk duty or something along those lines. Or you can suspend him with pay, which I feel like would just be a reward. Or you can suspend him without pay, which should have already happened, in my opinion, according to the agency. But that could be like a punishment. So to suspend him for a month without pay, and then he's back to his role or whatever. But that's not going to happen. I'm just saying, like that could be an outcome. All right. So an internal affairs investigation into Proctor's conduct remains ongoing. Officials have said this is a developing story and will be updated. And so, like I said, this is the most up to date information that I can find. When I have more information about Proctor's status, I will definitely make that known and keep you guys up to date. So let's move on and I also want to talk about, so this ties into what we're going to be reading about. So at the very end, stay tuned because I'm going to read this article from Turtle Boy Investigates or Turtle Boy Daily News. Turtle Boy Investigates. Turtle Boy is obviously Aidan Carney, who has been breaking this story for over a year now. If you're not subscribed to him, definitely do. Go subscribe to his YouTube page. We're going to read this article titled Three Not Guilty Error or Jurors Eliminated on Final Day of Karen Retrial. So we'll come back to this because this is related to what we're going to be reading about, sort of, regarding the whole was there some jury tampering maybe or some misconduct going on with dealing with the jury, handling things with the jury regarding Judge Cannoni. So let's dive in to our first reading here. We're going to first read the motion to dismiss, and this is the defendant Karen Reed's motion to dismiss, and this was filed earlier this morning around 9 a.m. All right, so now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court pursuant to the Fifth, Sixth, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her and those charges, and alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. So what are they saying here? They're claiming that all of the jurors took counts 1 and 3 off the table. So they were unanimous in reaching a decision that she was not guilty on those counts. So the one count, okay, so count 1 was second degree homicide. Count 2, which they couldn't decide upon, was the intent. It was manslaughter, which really deals with intent. Did she intend to back up into him? So Count one is she intended to. It was malicious. She had every intention of taking John's life that night. So they took that off the table. So count two is she might have done it, but or not might have. She did it, but it was an accident. Is count two. And then three was leaving the scene of an injury slash homicide while intoxicated. So it's not an it's not a DUI, it's not like an official DUI count. It is the fact that she left a scene where someone was gravely injured or their life had already been lost. At whatever that that's what that would cover is it was intentionally she left him there to succumb to his injuries. So that's what count 3 is. So they took counts 1 and 3 off the table and they were hung up on count 2. And there was no, what else that they're saying here? No manifest necessity supporting the declaration of a mistrial. So they don't, a mistrial shouldn't be granted in those counts. And then, because otherwise that would count as double jeopardy, is what they're saying here. So, which is obviously your constitutional right to not be tried twice for the same crime. All right. So, with a verdict, reaching a verdict, if you're found not guilty of something, they can't come back at you and try to get you again, supposedly. All right. So the ancient right, and I say supposedly because that's how it's supposed to work, but it doesn't always. Sometimes there are workarounds, and if a state can't necessarily prosecute you, the feds can, which would help us in this case if the feds would come in and start arresting the actual people that committed John's homicide. All right, so the ancient right to a jury trial is no more procedural formality, but rather a fundamental reservation of power to the American people. They're going to be citing a ton of cases. I'm not going to say them all. So, by requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, which seems to be happening here because they just keep coming back. They're like the Energizer bunnies. You can knock them down over and over again, but they just keep coming back. All right, so including the pursuit of pretended offenses and arbitrary convictions. Prominent among the reasons colonists cited in the Declaration of Independence for the break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams puts it, the founders saw representative government and trial by jury as the heart and lungs of liberty. So it is what keeps the government, not the government, our liberties, keeps our liberties alive is um, our ability to have a trial by jury and face our accusers. It is what it's a foundation of our country because that's why we came here. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The Double Jeopardy Clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and expelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. And that is a citation. All of these are citations and quotes, but it fits perfectly in this case. It's embarrassment, your whole reputation, and everything is smeared. People are smearing your reputation all over the internet. Her expense, um, she, I believe she lost her job or jobs. She had a financial career and she taught finances as well. And I'm not sure if she's still teaching, but I know that her career that she had worked so hard at, I believe they either let her go or told her to take time off. I don't know what it is, but I know that she lost that job. So that's expense and ordeal and compelling her to live in a continued state of anxiety and insecurity. It's extremely stressful to go to court for any reason. Any reason. It could be a parking ticket, any reason. Going to court and going up against a judge or a trial jury is it's got to be extremely nerve-wracking. I can't my body couldn't even take it. So, I don't know, I have anxiety already, so that wouldn't be good for me. And I'm sure Karen does with all the medical conditions that she has. I guarantee she's got some kind of anxiety that goes along with it because any kind of autoimmune disease or neurological disease that that or central nervous system type thing, it usually affects that. So um, there's that. Anyway, so perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. So you're violating her constitutional rights if you are hiding from us potentially or errantly um hidden from us either intentionally or errantly hidden the fact that the jury acquitted them of two charges that is pretty outstanding. And this is kind of a big deal. It's kind of a big deal. This stuff doesn't happen every day, and it's not every day that defense attorneys go around accusing a judge of potentially they don't necessarily accuse her, but in my mind, it makes me think there's some real shady stuff going on with Judge Bev, who I already thought she was shady and biased to begin with. It just proves my point, I think. Anyways, here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors. That's 25% of the jury pool or of the jurors came back and wanted to speak. They reached out. In Massachusetts, you're not allowed, the attorneys are not allowed to go reach out to the jurors. Apparently, there's a law that you cannot do that. And so these 3 jurors that they are hearing from, that the deliberating jurors, they were in those rooms deliberating, and they came to the defense to talk. Unsolicited communications from 3 of the 12 deliberating jurors indicating in no uncertain terms that the jury had a firm 12-0 agreement that Ms. Reed was not guilty of 2 of the 3 charges against her, including a charge of homicide in the second degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorized defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of two of the three charges against her prior to indicating to the court that they could not reach a verdict on the third charge alone. What? So, yeah, they I really think that the Commonwealth rigged this somehow, some way to go this way. I don't know, but or they were got somebody might have been gotten to by the McAlberts. Anyways, so well, 1 and 3 charges 1 and 3 should be dropped. And if the court believes that they need more information, if Judge Canoni wants more information from the jurors, then the defense wants a post-verdict inquiry held on this issue. And they also want the court to let the defense, because of this rule in Massachusetts that you can't talk to the jurors after the trial ends, they are asking the court permission to get additional proof from other jurors. They want to be able to reach out to other people that were on the jury so that they can have more corroboration and just do an investigation on their own, which the court should do also, but I doubt they will. So three charges against her, two prior. Okay, so that's the part that I was really stuck on here is the prior to indicating to the court that they did not reach a verdict. So they this document is stating that those that the jury came back and told them this prior to Judge Canoni even reaching a verdict. They said counts 1 and 3 should be off the table. But so she this is saying she's aware of the knowledge that the jury took those off the table. They thought she was not guilty on counts 1 and 2, and they were only saying that they were hung on the second charge. But Judge Canoni just declared a mistrial all around, which would mean that it is double jeopardy if she's taken back to court or to trial by the Commonwealth for counts 1 and 3 because Judge Canoni failed to put it on the record, which means she either did it on purpose or she did it negligently, errantly. You guys decide. Based on how she treated the defense this whole time and how she's ruled, what do you think? Makes me sick thinking about how corrupt I mean, it's like I've been saying, the judge is corrupt too. There's just no other way around it now. It's pretty evident. All right, so the background. On June 9th, 2022, Ms. Reed was charged with 3 separate indictments with homicide in violation of MGL, whatever, count 1, vehicular manslaughter in violation of MGL Chapter 265, whatever, count 2, and leaving the scene of personal injury or loss of life in violation of MGL, whatever those are. I don't know how to say all that. Chapter? Is that a chapter? I'm assuming, but I don't know. All right, so a jury trial began on April 16th of this year. On June 25th, the jury began deliberations. On July 1st, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court and, without providing any opportunity for the defense counsel to be heard, the court declared a mistrial and excused the jury. Footnote number 1 says, while the jurors note as read by this honorable court, indicated the impasse was on charges. It did not say whether the charges were those within count two, the multiple ways to find guilt on count two, or extended to other counts. The affidavits attached herein indicate the former, not the latter. All right, so in support, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to one, two, or all of the charges in the indictment. And that's what everybody was saying. It was very odd when she just was like, okay, that's it. It's a mistrial. Goodbye. Like, okay, jurors, go back and I'll see you out in chambers or whatever she says. And then she schedules really quickly with Yannetti and Lolly, and they have a hearing on the 22nd of this month to discuss what the Commonwealth wants to do if they're going to move forward with charges again. And now it might appear that they can only move forward on manslaughter if they were to move forward on anything. So that's good news. Good news for Karen. All right, so the following day, on July 2nd, 2024, Attorney Jackson was contacted by a juror in this matter. Juror A, who stated that he or she wished to inform Jackson of the true results of the jury's deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count one, second-degree homicide. Juror A was emphatic that count one, second-degree homicide was, quote, off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count three, leaving the scene with injury or loss of life. Another day later, on July 3rd, 2024, Attorney Yannetti was contacted by two different individuals hereinafter, Informant B and Informant C, who had received information from two distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. So Yannetti was contacted by two informants who knew people on the jury, if that makes sense. So there's Jackson, an intermediary, and then the jurors. And that he talked to the intermediaries, informant B and C, regarding jurors B and C, if that makes sense. And they were both deliberating jurors. So Yannetti, according to Yannetti's affidavit, we'll read that later. All right, so informant B sent attorney Yannetti a screenshot that he or she had received from someone hereinafter, intermediary B of text. Okay, so there's another intermediary. Sorry, so okay, so now we've got informant B, and then now we've got an intermediary. This is confusing. All right, so a screenshot he or she had received from someone else of text messages that intermediary B had received from juror B. So now, so is it two times the two or three times hearsay? I don't know. I can't keep track. It's too convoluted. In that screenshot, juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she did hit him on purpose or even thought she hit him on purpose. And that's the texter's error there, how they wrote that. They might have said, and speculating, maybe no one thought she did it intentionally or that she even hit him at all. But that's my All right, so informant C had been in contact with another individual, intermediary C, who is a coworker and friend of juror C, and joined a Zoom meeting during which juror C discussed the trial. So juror C was on a Zoom meeting with intermediary C, and then informant C told Unetti about this. Informant C sent attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what juror C revealed in the Zoom meeting. Intermediary C says no consideration for homicide 2, manslaughter. Manslaughter started polling at 6-6, so they were split in half, then ended deadlocked at 4 no, 8 yes, which is interesting. They were leaning more towards guilt in that regard, but were hung. So informant C says, interesting, if it was no consideration for homicide 2, wouldn't she have acquitted on that count and hung on the remaining charges? Going back to the jury verdict slip, that was all confusing. Intermediary C says she should have been acquitted. I agree. Yes, the remaining charges were that they were hung on. The remaining charges were that they were what they were hung on. And that instruction paper was very confusing. Now, the argument. So, the jury's unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. Here, the attached affidavits by attorney Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. So that's now multiple people, multiple jurors have come forward and said that she was not guilty on counts 1 and 3. Juror A was emphatic that count 1 was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. So that is pretty definitive. I mean, you can't really mince words and say, maybe it wasn't guilty. You can't at that point. All right, so David R. Yannetti affidavit. It was not guilty on second degree. No one thought she hit him on purpose or that she even thought she hit him on purpose. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. So, because it wasn't written on paper, that doesn't mean that because they spoke it and verbally agreed on that, that it doesn't count. It still counts, even though they didn't write it on the form. If they didn't, we don't know because if they did, Judge Canoni might have hidden that from us. Because if there's some misconduct going on there, I would not put it past the Commonwealth to hide such things. All right, so the Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital homicide and first-degree homicide, but split on manslaughter. The court The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree homicides. In doing so, the court relied heavily upon the lack of finality of the jurors' report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination that persisted through the end of deliberations, even assuming arguendo, and that just means like in argument of, even assuming arguendo, contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. All right, B. Re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. So there was no necessity for counts 1 and 2 to be called hung. So therefore you can't enforce that it was hung if they were in agreement. All right, so thus, where a mistrial is entered without the defendant's request. Reed, here Ms. Reed did not consent to the declaration of a mistrial. See also Commonwealth versus Edwards, rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. So, absent the defendant's consent, state and federal double jeopardy protections bars, as a general rule, the retrial of a defendant whose initial trial ends without a conviction. The rule is rooted in the importance to the defendant of being able once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, 1. Counsel must have been given full opportunity to be heard, and 2. The trial judge must have given careful consideration to alternatives to a mistrial. Sorry. Okay. So basically, Bev didn't give them a chance to talk, number one. And number two, she needed to double check. She needed to poll the jury. She needed to ask if they were hung on all counts or just one count, or which counts, if they were hung on 1 and 2 or 1 and, if a combination of whatever. So it was her job to poll them and find out. And if there was a way an alternative to a mistrial, which there is an alternative to a mistrial in the sense that counts 1 and 3 could have been a not guilty. So the only mistrial, I guess, would be in the manslaughter charges. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. So she just looked at the note, read it, and said, bye. Counsel didn't have an opportunity to react, to speak on the record about it, to say, well, Your Honor, we would like the jury polled. No, she didn't even give them that opportunity. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. She was just like, nope, okay, bye. My courtroom. The record is independently lacking on the second prong as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, unanimity, that's fun to say. Indeed, the virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. So you can still arrive at a partial verdict in this case, therefore, it shouldn't have ended in a mistrial the way that it did. The Supreme Judicial Court's holdings in the Commonwealth versus Ross, Massachusetts, that courts should not request partial verdicts on lesser included offenses charged in a partial court if in a single count. Wait, what? Read that again. The Supreme Judicial Court's that courts holding that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. Okay, there we go. Sorry. As the Roth Court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion. Um, There's some note here. Massachusetts law, to the contrary, clearly permitted the jury to return a partial verdict on some, but not all counts in that case. All right. So such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here the jury was asked to return three separate verdicts on three separate counts. In this circumstance, where the jury reports a deadlock without specifying the counts on which it is reached at an impasse, it is a straightforward and the defense contends constitutionally required follow up to ask whether the deadlock relates to some as opposed to all counts. Indeed, the Supreme Judicial Court has explicitly stated where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on the other counts. I mean, this is clear cut law, and it's pretty basic stuff that Judge Canoni should have known. All right, so alternatively, the defense is at least entitled to conduct post-verdict inquiry. Undersigned counsel did not initiate the communication with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. We're going to read them. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and/or an evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, the defendant asks that the court authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty on counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which she was previously acquitted by a jury, and the defense submits that post verdict inquiry is equally warranted in the present context. So there's multiple reasons why we should be able to inquire the verdict or inquire all of the jurors what their verdict was in each of the counts. Just as the count in McCallop approved questions as to the existence of racial bias, questions about the matter more attenu- att- attenuated from the contents of deliberations whether the jury had unanimously concluded that Ms. Reed was not guilty of counts 1 and 3 do not invade the heartland of jury deliberations but preserve the defendant's precious rights to the favorable outcome of the jury trial and to the protections of the Double Jeopardy Clause and its related state judicial protections. So basically, there's like the law, the unwritten law that, or maybe it is written, I don't, probably is written, that jury deliberations are like sacred. You're not supposed to ask what goes on. You're not supposed to talk about, like you're not, us, the outsiders, anyone who didn't deliberate in that room really shouldn't interfere. And they can't interfere. The judge, the lawyers, they're not supposed to interfere either. So it's supposed to be this sacred thing. And um, sorry, I lost my train of thought. um, I had it. I was gonna um, bring that back to this, but anyway, so deliberations are this sacred thing on the, and that's what I was saying. Okay, so they're sacred, and anyone that's not inside that room really doesn't need to know what goes on in the jury deliberations and what people say and how they get there. But they're not saying they're not asking to, learn of procedure and technique and, the secrets of what was going on behind closed doors in this jury in for this jury's deliberations. But they are asking, we just want to inquire what their votes would have been. How would they have um it's hearing like a ticking. How would they vote now, was it on each of the counts? They need to find out what each one of the jurors had, what's the word I'm looking for? How they found her on each of the counts. So, um, hold on. Sorry. Okay. So I was saying, just they're not asking to um, violate any kind of uh, any of the laws that respect the deliberation process and all of that. They're not trying to get into that. They just want to know, how did they um, find her on each of the counts, and that is within her rights to learn that information because that has everything to do with if she's going to be retried and if they can retry her on certain counts. I also want to know if there's some misconduct going on because I really feel like there is. That's me saying that. But I'm sure the attorneys also want to know what kind of misconduct is going on behind the scenes that they can't get it together in this jury. Yeah. Anyways, conclusion. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court issue an order dismissing counts 1 and 3. And it's signed David Yannetti, Alan Jackson, and we have a new attorney on here, which is his name is Martin Weinberg. And he filed his appearance in this case today as well. I'm assuming he's on the case because the attorneys are probably going to have to be um, called as witnesses in the hearing. And also Judge Canoni is probably going to be called as a witness because remember, she called them back. You know what? Let's play it. Hold on one second. All right, here we go. This is when she calls the mistrial.
Muted.
Thank you. Be seated. Closing session.
22-117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
So she doesn't even give the attorneys an opportunity to look at the note. She just says they're at an impasse and we're bringing the jury in after she just calls in the attorneys. So it's not like they were actually ready to expect something in particular or prepared to argue one way or another, like, well, can you pull them or something? All right, the jury's coming in. There's Turtle Boy back there and Paul O'Keefe.
All right, Mr. Foreman, I am in receipt of your note. Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes, so thank you.
I'll be in to see you privately in a few minutes. I know we all caught it the first time, but just wanted to point it out again.
Thank you so much for your service. Okay.
All rise to the court, please.
Therefore, she made herself a witness by going and meeting with them privately. And it's good reason to take her off the next case if there isn't a free trial. The jury leaves.
All right, I'd like to pick a status date to find out what our next...
She just lets the jury leave. No questions asked. They weren't given an opportunity. And then immediately goes to, okay, what's next? Let's set a status hearing. So there's that. All right, so let's read the affidavits of Alan Jackson and David Yannetti. Oops, let me switch back to my other screen. All right, so this is the affidavit of Alan Jackson in support of the defendant's motion to dismiss. And I'm sorry, it's blurry. It's blurry on my end too. It's a screenshot of somebody else taking a picture and not the best, but that's what we got. All right, so I, Alan Jackson, declare, number one, I am a partner at the Los Angeles law firm of Worksman, Jackson and Quinn, LLP, and I have been licensed to practice since 1994. Looks good for his age. I am counsel for Karen Reed, appearing on her behalf in the Commonwealth of Massachusetts Pro Hoc Vice. On Tuesday, July 2nd, 2024, I was contacted by Juror A, true name and identity withheld to maintain anonymity. Based on my conversation with Juror A, and that juror's description of who he or she is and where he or she was seated, and certain identifying information, name, occupation, disclosed during the voir dire process, I was able to positively identify which juror he or she was. Number three, Juror A told me that he or she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Number four, Juror A stated that he or she wished to be respectful of the privacy of the deliberation process, that sacred space that no one's supposed to interfere with. So she wants to be respectful of that privacy, he or she, but they wish to inform Alan Jackson of the true results of such process. Juror A indicated that he or she believes it important to disclose such results because he or she believes that those results significantly impact Miss Reed's rights. So that's huge because if what they're saying is true and what they're claiming is true, then Miss Reed's constitutional rights are being violated once again by the Commonwealth, trying to retry her for charges she was already acquitted on, which seems like something the Commonwealth would do. I mean, are we really surprised at this point? I mean, I'm not. I'm really not. All right, so Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count one, second-degree homicide. Juror A was emphatic that count one was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. 6. Juror A told me that shortly following that determination regarding count one, the jury also unanimously agreed that Karen Reed is not guilty of count three, which was leaving the scene. Number 7. On July 1st, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. So do we even know if the note was the note that the jurors handed to them? Do we know? I, for one, would like to know. All right, so once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. We just saw it. It happened exactly the way Alan Jackson just described it. Number 9, neither Ms. Reed nor her counsel consented to the entry of the mistrial. Number 10, defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. She didn't ask. Number 11, nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse and whether the jury could or did reach unanimous agreement on any of the other counts. She didn't ask him a damn thing. And number 12, had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count one and count three. She didn't want to ask them because she probably didn't want it on the record because she's corrupt, just as corrupt as the rest of them in the Commonwealth. Ms. Reed was denied her rights to receive those verdicts in her favor. She was denied that right, and it is your constitutional right. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States and the state of California and the Commonwealth of Massachusetts. That's all where he practices law. Okay. So, well, he practices in California, but he's semi-practicing in Massachusetts as well for this trial. All right, so now this is David Yannetti's motion, affidavit in support of motion to dismiss. So I, David R. Yannetti, do hereby depose and state that the following is true to the best of my knowledge and belief. Number one, I am an attorney licensed in Massachusetts since December 20th, 1989. My main office, he looks really good for his age too, by the way. Maybe he looks even better for his age because he looks not, I mean, they both look young. They don't look like they are the ages that they are. I'll say that. Not that it matters. All right, so on January 29th, 2022, I was retained to represent the defendant Karen Reed regarding the above captioned matter. So he was retained the very same day that the incident happened. And that's significant because they were already suspecting her. Proctor had called to let them know they were on their way to come and talk to her, and then they tow her car away from her parents' house. And at that point, they threw her in the hospital and tried to get blood alcohol. Uh, that's my dog moaning as he walks or as he lays down. I don't know if you heard that. Um, what was I saying? The blood alcohol. They tried to get her blood alcohol in the morning, so I'm sure she was probably fearful that they were going to get her on at least a DUI, if not for his loss of life. I mean, I don't blame her for retaining counsel that day, and it's smart that she did, and fortunate that she has the means to do that. Number two, on July 3rd, 2024, I received communications from two different individuals, hereinafter Informant B and Informant C, who had received information from two distinct jurors, herein Juror B and Juror C, both of whom were part of the deliberating jury in this case. Number three, to my knowledge, Informant B and Informant C do not know each other. On Number four, on July 3rd, 2024, Informant B sent me a screenshot that he or she had received from someone of text messages that intermediary B had received from juror B. So there's a bunch of B. There's an informant B, there's an intermediary B, and then there's a juror B. In that screenshot, juror B texted the following to intermediary B. Quote, it is not guilty on second degree and split in half for the second charge. When the judge sent us back with the Hernandez thing, he means the Allen charge. What's the other term for it? Oh gosh, I just had it in my brain and now I forgot it. It's not Hernandez. It'll come to me, maybe one day. All right, so when the judge sent us back with that Allen charge thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left. Based upon the first name of juror B given to me by informant B, I believe I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. Number six, on July 3rd, informant C contacted me to say that he or she personally knows juror C as they used to work together. Informant C and Juror C also have a mutual friend, hereinafter intermediary C, who is a current coworker and friend of Juror C. Number seven, Informant C told me that he or she had posted something about the Karen Reed case on Facebook on Monday, July 1st, 2024. He or she told me that he or she believes that post led intermediary C to text him or her or inform him or her that juror C was a deliberating juror on the case. Number eight, informant C told me that he or she thereafter reached out to juror C via text message and discussed his or her experience as a juror in very general terms. They described what an exhausting experience it was and what juror C was then that juror C was relieved it was finally over. Number 9, intermediary C told informant C that juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Number 10, today, informant C sent me 3 screenshots of a text message exchange he or she had with intermediary C. Informant C told me that intermediary C was reporting to him or her during the exchange that juror C had revealed during the Zoom meeting. Text message exchange reads as follows. Intermediary C says no consideration for homicide 2. Manslaughter started polling at 6-6, then deadlocked at 4 no, 8 yes. He or she was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, he or she voted no because the cause of his loss of life was twofold of hypothermia and head injury, of which he or she was convinced that the vehicle did not cause both. The jury felt very intimidated by Higgins' presence at the end. And we believe, I believe, that they meant Brian Albert, not Brian Higgins. They just said the wrong Brian. When there were so many witnesses to keep track, it's no wonder the jury was confused on some of this crap because there were so many witnesses that the Commonwealth called that they didn't need to call. They were so repetitive. And it was hard enough with all the players within the case, but then you call like 1,700 different firefighters to say the same thing and that it was snowing. And yeah, so I don't know. It was annoying to watch that. To watch so much repetitive stuff coming from the Commonwealth. Anyways, continuing on, the whole jury felt very intimidated by Brian Albert, and his presence at the end of the closings. He or she's not sure what he or she's going to do. He or she's going to lay low for a couple of days and see where it takes them. Hasn't ruled on anything. The jurors all have a group text going. Informant C says, interesting. So that's all from intermediary C. Now, informant C says, interesting. If it was no consideration for homicide 2, shouldn't she have been acquitted on that charge and hung on the remaining charges? Goes back to the jury verdict slip, and that was all very confusing. Intermediary says she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. Informant C says, what a great experience for him or her. Amazing that they let the Alberts in the last day, that they let the Alberts in. Intermediary C says he or she felt very honored to be part of it. He or she was redacted physical description of the juror. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. Informant C says that's the way it should be. I knew it was an intelligent jury. They will be studying this case in law programs for years to come. I'm in how to investigate and try how not to investigate and try a case. Yes, definitely. This will be studied for sure. If they all agree on no for homicide 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she is retried on that charge. So thankfully, these jurors were talking to friends and people. We're talking back to that, having, they're open. They might be scared to come out publicly because the media and how crazy this case is, but honestly, uh, they are free to talk to whoever they want, media or, friends and family. I'd be talking to my friends and family about it, as much as I could if I was on a case like this, but I'm also a weirdo and I love true crime. But anyways, um, we're not weirdos for loving it. we are very interested in the human behaviors and actions of others. And that's why I think that law and true crime is so interesting to study because it's all about like human behaviors and the way people think and stuff. So, anyways, that's my opinion. Where did I read that one? Jeopardy. Yeah, so it's a good thing. What I was saying was it's a good thing that all of these jurors had people to talk to and they're telling them like you got to tell someone or you got to come forward. So otherwise, we might not have known this. And there's probably other jurors that are out there saying, I really believe that there was some corruption going on and they need to tell. They should speak up, even if not publicly, go to Yannetti or Jackson or the DA, but I wouldn't go to the DA. I would go to Yannetti and Jackson. Number 11, based upon the description of juror C given to me by informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror he or she was and confirm that he or she was a deliberating jury signed under the pains and penalties of perjury this 6th day of July. So that is the motion to dismiss and the affidavits of Alan Jackson and David Yannetti. And what do you guys think? I really want to know what your thoughts are regarding this jury shenanigans. Is it misconduct? Is it an error? Is it negligence? What do you guys think it is? Do you think they did it intentionally to keep these charges going and keep Karen on the hook? I, I personally think so, but I don't need that much convincing that Judge Bev is very, very biased. All right, so as I promised you, I'm going to finish this episode with a an article. It's not very quick. So if you can give me just 1 second, I'm warm. I need to like stretch for just 1 second and then I'm gonna read this. So hold on. Okay, sorry about that. That's better. I needed. You know what? I'm gonna put my hair up too. All right. So this is the Canton Cover-Up. I didn't even realize when I titled my thing that Turtle Boy had the same title. So, whoops, I must have titled it that because I've heard him say that or whatever. So, it must have been like a subliminal or subconscious thing. So, sorry, I wasn't trying to steal Turtle Boy's title. And I'll never get to part 369. I leave that to him to cover all the parts in the Canton Cover-Up series that he has going on. Anyways, so this is Turtle Boy has a blog and he writes on it regularly, usually daily, but with the case, with the trial going on it, he hasn't been writing in it as frequently, but he still has been keeping us up to date on certain things. And this is the 3 not guilty jurors that were eliminated on the final day of the Karen Reed trial. So if you recall, on the very last day before closings, I believe it was before closings, they were delayed a couple hours. And it was because I think it was like an hour and a half to 2 hours or something. They were dealing with some of the jurors. And this is why. So this is coming from Turtle Boy's blog in Kearney. He usually comes with receipts, so I'm just gonna say, a lot of people don't like him. You can not like him, but still believe that he comes with accurate reporting. So I personally like him. All right, so one of the 3 jurors not chosen to vote on Karen Reed's guilt or innocence is speaking out about her thoughts on the trial. According to her, she would have voted to acquit. And I guess here's the video of it.
At 6, we are hearing from a juror in this case.
WBZ's Louisa Moeller spoke to a woman who was actually one of the alternate jurors.
I just spoke with a member of the jury in the Karen Reed trial. She would like to be referred to As juror number 3, obviously these folks have been through 9 weeks of hard work. She did not want to go on camera, but was willing to let me take some handwritten notes, and I'll consult them for accuracy. So juror number 3 was an alternate in this trial. That means that she was present throughout the entire trial, could listen to evidence and testimony, but was not present during deliberations. First, I asked her, how do you feel at this moment? She told me, quote, exhausted and disappointed. She told me she was, quote, not in the room where it happens. That's the deliberation. She said, quote, it was a lot to sit quietly in a room for almost a week. There were, of course, 5 days of deliberations. I asked her what she thought about this case and Karen Reed's guilt or innocence. She said, quote, I approached this trial as if I was taking one of my graduate level classes. I would get an A+ in note taking. And then I'm paraphrasing here. She says, I believe the Commonwealth did not do their job to convince me beyond a reasonable doubt that Karen Reed was guilty. Paraphrasing again, no one saw exactly what happened. She told me that watching both families throughout this process was painful and tragic. And then I asked her about Trooper Michael Proctor's testimony and his explosive and inappropriate texts about Karen Reed. She said his testimony would not have, even if it were not included in this case, she still believes that there would not have been enough evidence to convict Reed. As for the trial and the jurors, she says it was a lovely group of people. We celebrated birthdays. We even did puzzles together. Now, you've heard from my colleague Christina Rex and from legal experts that a jury is supposed to be representative of the public. And of course,
Christina Rex is the same individual who interviewed Paul O'Keefe, who did that little fluff piece on Paul O'Keefe and his family and him defending people like Jen McCabe, who did Google House Long to Die in Cold at 2:27 a.m., and people like Michael Proctor, who planted taillight at the scene and things like that. So he defended all that, but whatever.
Of course, if you talk to any member of the public, there's lots of differing opinions about this case. So there will certainly be more information from jury members and everyone else in the coming days. In Norfolk County,
All right. Go back to that. So I've played that before on my channel, but if you haven't heard that, there it is. So that's the only juror that we know of that has spoken out, other than now these explosive comments that are coming from the defense's motion to dismiss. So that is interesting. This says, question, how are you feeling? Juror 3 says exhausted, disappointed. I was not in the room where it happens. Okay, he just basically gave us the text there. So it's borderline cruel that they made the 2 alternates sit in a quiet room by themselves for 4 days after sitting through 31 days of testimony and becoming so involved in this case. A look of disappointment on their faces when they realized they wouldn't be able to vote on Karen Reed's fate after being subjected to 2 months of what, if anything, was like watching your kid find out that his bike was stolen. So these individuals most likely were obvious Karen Reed supporters, or some of these individuals gave, visible looks of disgust when Michael Proctor was on the stand, or they would shake their heads or look at people like, what is going maybe not that exaggerated, but they would make faces based on the testimony, and based on the faces that they were make, you could tell that they were more in support of Karen Reed, not the Commonwealth, although that is subjective. So you never know what's going on in somebody's head. But the fact that 3 of the jurors that were Karen Reed, pro Karen Reed, potentially, they got eliminated before jury deliberations. So 3 of them were he says 2 of them were in the room. It's cruel that they made two alternates sit in a room by themselves. Juror number 3, who I will refer to as juror number 13, because I counted the front row first throughout the trial, not the back row, was an educated woman in her early 60s with short brown hair and glasses. She sat in a triangle with juror number 12 and 3, and the three of them would make light conversation during breaks in the trial. The three of them were by far the most obvious in favor of an acquittal. They all made faces, showing their disgust when Michael Proctor read his text messages out loud. They looked baffled and shocked as Trooper Paul attempted to explain how Karen Reed's taillight caused the dog bites on John's arm before causing him to do a 360 and launch 30 feet in the air before the curb caused a 3-inch laceration in the back of his head, and he magically ended up 10 feet away from the curb on the grass. Exactly. Like what? None of that makes sense. One of them mouthed, "What?" as she shook her head, and that would have been me. Like it would have been so hard for me to keep my composure. According to Christina Rex, and again, this is the I was going to call her a chick, this woman who interviewed Paul O'Keefe. She says Trooper Paul is explaining exactly how he believes O'Keefe got his injuries. He says John O'Keefe hits a smooth taillight with his arm, spins, tail light shatters in the process. He is thrown to ground. A juror looks at him, then forward, shakes her head, and mouths, "What?" I love that for him, Joseph Paul, Trooper Joseph Paul. All right, so weeks ago, juror number 5 was dismissed for unknown reasons after she was called up by Judge Canoni. These same 3 jurors, 2, 3, and 13, were also called to speak with Canoni. The 3 of them reported juror number 5. So these 3 women who reported on juror number 5 then all become alternates. What are the chances of that? Seriously, what are the odds of that? Somebody who does math, figure that out. Because it's probably very, yeah, the chances of that are probably very low. All right, so after she was called by Judge Canoni, these same 3 jurors were were called to speak with Canoni. The 3 of them reported juror number 5 for something she said that led to her disqualification. It's unknown what exactly they heard juror 5 say. I believe it had been rumored that she made something about like she didn't like how Karen was smiling all the time or smirking all the time or something along those lines. And she wasn't supposed to say that, obviously. And so they told the judge. Coincidentally, these 3 women, the most obviously not guilty votes on the jury, were all eliminated as jurors last Tuesday. First, juror number 3 was called in front of Canoni after she was reported for allegedly talking about the case at a bar a month prior. They waited until closing arguments to report to the judge, something that happened months prior. She seemed very upset and denied any wrongdoing. So, yeah, I'd be pretty mad if they dismissed me off the case just because they had some word of mouth, whatever about a bar that I was at and I said something and I didn't do it. I'd be mad. It's notable that the Massachusetts State Police are in charge of juror security. This means that an employee of the same organization that Karen Reed's defense team is framing her for John O'Keefe's homicide is in charge of deciding who gets kicked off of her jury. Does that make sense to you? Michael Proctor, Yuri Buchanan, Brian Tully, and Joseph Paul could all see the facial reactions of jurors as they testified. Coincidentally, it took a full month for a juror who made it obvious that she was disgusted by them to be, quote, reported to state police and removed as a juror. It's unknown to everyone, including the juror herself, who reported her to state police. After closing statements that day, so the one woman was dismissed, the other 2 were put in as alternates and were not allowed to deliberate. After closing statements that day, a lottery was held to determine which two of the remaining 14 jurors would be alternates. Coincidentally, clerk Jim McDermott drew the numbers for juror 13 and then juror 12. Juror 12 was seen crying when she came into court the next day. McDermott did not show anyone the numbers, including the Reed defense team, who asked to see them later on. That's a problem. That's a problem. You got to have transparency in this stuff, guys. And that's one thing that the Commonwealth does not have. Although there's a lot that's been come to light in this last trial, I'll tell you that. The statistical odds of the three most obvious not guilty jurors, who are the exact three who reported another juror for misconduct. Here we go. Somebody did do it. Being the three that were eliminated from a pool of 15 is 455 to 1. Okay, he breaks it down. These odds are slightly better than the odds of two men butt dialing and butt answering each other while one is sleeping and the other one is making love to his wife at exactly 2:22 a.m. So of course, the court didn't find it odd. Statistical improbabilities happen all the time in the Karen Reed case, but you're the conspiracy theorist if you think a cover-up is possible. Exactly. We're the weirdos here. All right, so we don't know what the vote count was on the jury. Well, now we do. And the list of jurors will not be made public since it was a mistrial. If any jurors would like to speak with me about their experiences, they can DM him on Twitter and email him. He was not going to dox anybody. There you go. So now you have it. We see that there might be some misconduct going on in the Commonwealth, especially when it comes to jury selection and shenanigans going on with the jury. And how can we trust the jury selection process and all of that jazz if we know that the jury selection is under state police who are also corrupt? And they're the ones that should be on trial here. So how are we supposed to be trusting that process? I don't know. I do not know. You guys like my background? Pretty sky and mountains. Anyways, that is the latest I have for you in the Karen Reed trial. I hope you enjoyed this. Please don't forget to hit the like button on your way out and be sure to make sure that you're subscribed because I'm going to be putting out another video shortly in the next couple days regarding what happens when there's a hung jury. What are the implications of that? You know, what happens to the individual? How many times can you keep going on retrial and things like that? So we're going to get into all of that next time. So please hit the like button, hit the subscribe button. Let me know in the comments what you think about this crazy case. Could it get any crazier? Are we going to see Judge Canoni as a witness in a hearing, which would be phenomenal? I can't wait if that happens. That would be great to watch. Anyways, let me know your thoughts below. Thank you guys so much for watching. Take care and have a good one. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.